Can you please look up this site?
See if we can figure out something.
Hey, little bit of a last minute decision to go live here because it is Memorial Day weekend. My hair's a little wild because I just washed it and then went into a call. I'm also in the lounge because the cats had completely taken over my office. And now that I've set up the entire thing here, they're right next to me on the couch with Fawn. So that worked out well. I wanted to watch a Judge Simpson stream that we didn't see the beginning of the other day. However, I've just been kind of down a little bit of a rabbit hole because I completely lost touch with apparently what is going on with everything to do with Rekeita law. And now I'm trying to find the arraignment. That doesn't necessarily have all the commentary. So I'm going wherever people go when they can't find answers in the world, obviously to Reddit. It looks like some of this I actually can't play. Oh. I found a channel that has clips. Give me a sec. I just saw it. The one I just chose starts very clearly with strong language. So this person has taken a snippet from MLS God of Law, but I'm not going to credit the person that I'm watching now. I'm going to credit where they got it from. Hey, Sim. I just quickly need my copyright. Wait. Is it this? Yes, it's this. Let me just quickly put my banner up so I don't get in trouble. And then I'm going to put myself like this. And let's do this.
So while we're waiting, as I stated on my stream earlier today, my only real concern is for Nick and for his kids and their a positive outcome here, and that's largely going to be up to Nick.
Yep. Let's see. Pin. Hang on a second. Oh, there we go. Let me rearrange my screen here. There we go. All right. Yeah, it is. It's definitely going to be up to how Nick handles this going forward. There's a game to play here. There's a system to play into at this point.
Kill niggers, behead niggers, roundhouse kick a nigger into the concrete.
Wow.
You knew this was coming, people. Yeah, it depends on how Nick plays into the system. And he can definitely play it the right way. And he knows how to work this system. So
This particular, I mean, these criminal circumstances are frankly the least of my concerns. I mean, whatever, I think he'll have a reasonable outcome here unless he really screws that up. But I'm thinking about the rest of his life.
So in case you can't see who the two people are, it is MLS, God of Law, who I'll put his full video link in the description, and then attorney Andrew F. Branca.
well, that's true. He again, this is an opportunity for him. We've seen him on the streams. There's been rumors of drug problems.
That ding dong.
It seemed to be somewhat more credible now, right? And so this is an opportunity for him to. When I say play the system, you're not playing the system. You're taking advantage of the system, right? If you use this as an opportunity to get clean, he can come. This could be one of the greatest comeback stories. You know,
it should be
out there.
Good morning, everyone. We're going to go on the record. Before we do, a couple rules this morning, giving the amount of observers. First, you are to turn off your device so you are muted and turn off your video camera. Second of all, there have been requests to record this proceeding. Those requests are denied.
Hey.
The rules, general rules of practice prohibit any recording.
Okay, this might be a dumb question, but given that, how do these two have this? And they're lawyers. And I'm just going to say a disclaimer right now that I have gotten this from it being out there on the internet in public domain. I didn't have to dig for it. It was right there. In fact, his original stream is what made me stumble on this whole situation.
Recording other than the official record of the judicial branch, which is recorded by a certified court reporter. I imagine that transcripts can be available. That's under General Rule of Practice 42 or 4.02, Subdivision 5 at Prin 5. I need to tell everyone that a violation of that rule could lead to contempt proceedings. We are on the record in 34 CR 24.
For the record, I have an email.
And Madam
Okay.
Clerk, if you can
Yeah.
disable that, the buzzing or bell noise each time someone joins us, court would appreciate that. This is the state of Minnesota versus Nicholas Robert Rekeita. Am I saying that correctly? You've told me before.
Yes, sir, Rekeita.
I have your date of birth is December 16, 1981.
Yes, sir.
Currently reside at 12291.
They obviously blocked his address, not me.
Okay.
I would.
Your appearance today is based on 3 counts to a complaint order for detention. The record should reflect that Alex Kornahachi appears for the state of Minnesota. Mr. Rekeita, you are self-representing yourself at this point?
Yes, sir.
Okay. Count 1 is second-degree possession, 25 grams or more of cocaine or methamphetamine. This is in violation of Minnesota Statute 152.022, Subdivision 2, Prin A, Prin 1. The maximum sentence for that count is 25 years in prison and/or a $500,000 fine. Count 2 is possession of ammunition or any firearm with the user of controlled substances. This is a gross misdemeanor, so the maximum sentence is 364 days in the Candioi County Jail and/or a $3,000 fine. Count 3, endangerment of a child when present with a sale or possession of a controlled substance. Again, a gross misdemeanor. Maximum.
Get all your coke out, Nick, and kill yourself, you stupid motherfucker.
I'm going to warn everyone again, this is a court proceeding. If you were in a courtroom with me, the judge would remove you. So any
Judge,
violation of that will be removed. Ms. Block?
Judge, I just disabled people the ability to unmute themselves, so I will work to unmute people as they need to speak to the court this morning.
All right, thank you. Aside from Mr. Rekeita and Mr. Kornahachi, no one needs to at this point. Lastly, I think I was saying that the count 3 gross misdemeanor has a maximum sentence of 364 days and/or a $3,000 fine. Mr. Rekeita, you understand what you've been charged with, and second question, the maximum sentences associated with each count?
Yes, Your Honor.
All right. Now, I don't mean to insult your intelligence, given you are an attorney, but it's important that I know that you understand your rights here. First of all, you are presumed to be not guilty of these charges. It is the state, not you, that has to prove what has been alleged in the complaint with evidence beyond a reasonable doubt. You have a right to trial by jury. All members of the jury would have to agree that the state had met its burden of proof beyond a reasonable doubt before you could be convicted. You have a right to counsel. You have a right to represent yourself, of course. If there's a trial, you could give your side of the story and testify, but you also have a right to remain silent. Indeed, you don't have to prove anything, so you don't have to say anything. If you remain silent, the judge can't make a comment about that. The prosecutor can't make a comment about that, nor can the jury take that into consideration. You have a right to confront, challenge, or cross-examine anyone who testifies against your interest. You have a right to call witnesses and the power of subpoena. You have a right to all of the state's discovery before trial, and including exculpatory information and evidence. And at the end of the day, if you think the court made some mistakes or a jury made some mistakes, you have a right to appeal. Any questions about those rights as I've explained them?
No, Your Honor.
This is a Rule 5 hearing. Sometimes we call it a bail hearing. We'll set this for a Rule 8 hearing. Under the rules, you have a right to have that hearing within 14 days of today's hearing, but you could waive that as well, given your right to seek counsel if you so choose. Do you want this scheduled within 14 days, a Rule 8?
No, Your Honor, I'd like to waive that. We can combine it into a contested omnibus hearing. That would work.
All right, so we could, for today's purposes, combine Rule 5, Rule 8?
Yes, sir.
All right. And before you ask for a speedy, you want to hear what the state...
There's 20 minutes left of this, and if they don't turn off that bell sound, I don't think I'm going to make it through.
is requesting
Yes,
as far as
hear what the
these
state is
conditions?
Yes, I'd like to hear what the state is requesting.
I didn't say it, but you also have the right to have me read the complaint today.
No, I'll waive that right, sir.
All right, very well. Mr. Kornahachi, what is the state requesting as far as release conditions?
Yes, Your Honor. The state is requesting $50,000 unconditional. In the alternative, we would agree to RPR with standard drug conditions, which would include no use, random testing, no use and possession of firearms, contact probation as directed, don't leave the state without permission from the court, remain law-abiding, keep in contact with probation, and other standard conditions.
Mr. Rekeita, any objection to those conditions?
I object to the $50,000 bail. I think it's unduly burdensome and in violation of the Eighth Amendment.
All right, what about the conditions?
Release conditions sound fine.
All right, the court will set unconditionally amount of $50,000 cash or bond. Conditionally, you'll be released on your own personal recognizance. In all instances, you need to be law-abiding and show up for all your court appearances. Conditions are as follows: abstain from the use of alcohol or any mood-altering chemicals not prescribed by your physician. That will be subject to random testing. So the court will order that you meet with probation upon your release, sign their agreement, and cooperate fully. You're not to possess any weapons, firearms of any nature, or be in the presence of anyone with a firearm or dangerous weapon. And do not leave the state of Minnesota without prior approval of the court. Any questions about those release conditions?
Yes, Your Honor. Did you say 50 or 15,000?
50,000. 50.
Thank you, Your Honor.
Okay, let me ask this. Do you still want a speedy omnibus, or can it be scheduled in normal course?
You rescheduled in normal course, Your Honor.
Very well. Madam Clerk, do we have a date for that?
I'm sorry, Judge, I'm just going to interrupt. This is Katie Block, the court administrator. Do you want this next hearing to be in person or remote?
In person.
Thank you for the clarification.
Mr. Rekeita, you said contested, right?
Yes, sir.
Okay, so yes, in person.
And I'm sorry, Your Honor, just to clarify, timelines are waived?
Yes.
And Madam Clerk, just so the court is aware, Kristen Pierce is handling this case going forward.
All right, thank you.
You're welcome.
So while we're waiting for the date, $50,000 bond, cash or surety, which means he can
And the
pay.
matter has been assigned with Judge Fisher. I'm looking at Tuesday, August 20th at 2:45.
Good for the state.
Judge
Without
Fisher-
having a calendar, sounds great.
Very well. Any other business we can conduct?
Now,
Yes,
yeah, this. Oh,
Oh.
apologies. Go ahead.
Your Honor, I have requested to see two of my clients and have been forbidden from doing so. I would like to see them before their arraignment.
He's going to represent his
I'm not
wife.
understanding your request. Can you repeat it?
As two of my clients are set for arraignment today, I have requested to see them. They have both requested to speak to their attorney, who is me, and they have been prevented from doing so up to this point. I was wondering if we could get an order to allow me to at least speak to my clients before they come into their first appearance.
Gornahachi?
Your Honor, I'm not sure if the court is aware. April Multi has been released.
Okay.
And then I believe the other person who's referring to is his wife, Kayla. Is it Rekeita? Rekeita. I'll leave it to the court's discretion. They are charged as co-defendants. I believe she would have to waive any conflict, etc. But I don't take a position.
And to be frank, I don't know if that's a waivable conflict at this point, given they are co-defendants. But there's no request from the state that obviously they are married, so there's no request that they be separated. True?
Correct.
Well, it's an issue of denying counsel to Ms. Rekeita, so I will grant the request and leave that as an issue for Judge Fisher. At least to get us through the arraignment this morning.
Thank you, Your
Mr.
Honor.
Jailer, are you able to make accommodations? Mr. Rekeita, how much time do you need?
Not long, just about 15 minutes, Your Honor.
Can the jail accommodate that?
That'd be up to the jail administrator, Your Honor.
I'm sorry?
I would have to talk with the jail administrator.
All right.
Okay, so I'm going to pause because I think I've put together thanks to Reddit, a little overview. And I just want to say before that this is people on Reddit's opinions. I don't have an opinion. I literally just stumbled on this as I went onto YouTube to grab the link for Judge Simpson that I wanted to watch. I personally didn't watch this channel. Rekeita Law I didn't watch at all because I didn't like the drinking aspect. So I'm completely out of touch, and I was kind of like, when did this happen? What is going on? I had no idea. So here's the write-up from Out of the Loop. I've obviously censored some stuff and switched up some wording and whatever. So it's not exactly like this, but here's the overview. During the last 2 years, he fell into a massive hedonistic decline fueled by alcohol, sleep medication, and D's, which escalated into more and more unhinged streams. Lowlights include mocking and humiliating a fan who was wanting to self-terminate, who reached out to him, making jokes about his children being ... comparing Michelle Obama to an orangutan, calling a black entrepreneur the N-word, justifying people who implied to mock his grandfather's grave and harassed his business, and also humiliating himself by attempting to be a stand-up comedian during his streams. This is someone else's opinion. This is not my opinion, by the way. He tried to re-enter as a lawyer by representing a friend of his at a traffic court for speeding, but overslept the court date, which resulted in a much worse default judgment. He allegedly cheats on his wife with his ex-friend's wife, and his kids walk in on his binges of the other two things I mentioned earlier. He also insulted his fellow churchgoers on stream and shamed their way of worship, in brackets singing, while fully admitting to going to church so hammered he had to walk out during Easter service. Note that he is a trust fund child, only attending his congregation so his religious parents continue to subsidize his lifestyle. All this is just scratching the surface. It becomes really crazy once you consider he was putting on a conservative, family-centered, religious lawyer man persona beforehand. And then someone else commented this, and this I cut down a lot because I feel like there were just so many allegations that I cannot fact check that I'm not even willing to put out there at all. So this is heavily summarized down to the only the points in their comment that I think people can check for themselves. Lately, he's been spiraling more and more, being dangerously drunk and high on streams, posting, let's just say, rhymes with dude pictures of himself and aging like a man running out of something. This accumulated in his recent arrest for multiple felonies on both drugs and weapons charges. He has never really been a lawyer, but he may well lose his law license over this, and he may also end up serving jail time. That's to say nothing of the rumors that he was romantically involved with one of the women he was arrested with, specifically the one who is not his wife. It's going to be a rough road ahead for Nick, and I have to say it couldn't have happened to a better person, which is like incredibly harsh. But I did hear that it's him, his wife, and his alleged girlfriend are the defendants in this. And it's all surrounding illegal grown-up suites and potentially their family being there. That's what I've understood so far. I think that it might be a little bit more than that. I think there might be other elements, but I haven't found like definitive answers.
If they have any difficulties with that, the jail administrator, since I'll be in these proceedings, should contact Chief Judge Beckman.
Thank you, Your Honor.
Thank you. All right. Since Ms. Rekeita is not available, at least for the next 15 minutes, do we want to take the next matter?
Fine with the state, Your Honor.
Do we want to interpret the case next?
Which case?
The interpreter case?
Sure.
Okay. Thank you, Your Honor.
Thank you, Your Honor.
Okay, so we're going to pull down the screen. They're going to handle some other cases. I'll leave it going and see if Nick's wife, if her arraignment goes for a bit. Hopefully you guys can't hear all the dinging and stuff. I'll still hear it. But he's got $50,000 cash or surety bond, which typically would be he can go to a bonding agent and pay about 10%.
This YouTuber's full stream is officially linked in the description. I've added it, I've saved it. So if you want to watch the rest, and I would watch the rest, if I were you, then I've tagged and whatever, just go to the description. I don't want to. Okay, you're going to have to hold on a sec because you're going to go for a little bit of a ride. My shoulders are getting sore, so I need the laptop closer. I don't want to watch the entirety of his stream because I want traffic to go back there since I am watching what he put together that he had to put in requests for, etc.
And then they'll post the rest of it and he'll get out. And so long as he appears, there won't be any issue. Otherwise, I think Dog is going to come after him. Bronca, thoughts on Nick representing his co-defendant?
Well, that's what I would want to do if I were him. He wants a chance to talk to his wife before she goes in for arraignment. He also wanted to talk to this April person, obviously. It's an odd circumstance. She's already released, which is a little alarming, frankly.
Yeah, that the third is already released. Yeah.
Because that suggests maybe she's being cooperative to the detriment of Nick and his wife. Who knows? There's speculation on my part, but that would be consistent with her just being kicked loose. Clearly, Nick and his wife are not being kicked loose. I was a little confused about the conditions for release. It almost sounded like in the alternative to me, like $50K with no conditions or own recognizance with the conditions.
Yeah, I was too. I'm not familiar with the phrasing of the 50,000 unconditional. I don't really know what that means out of Minnesota because we don't really have that terminology here. It would be 50,000 cash or surety, or 10% is a third option in Michigan, which sounds like it's not happening here. But then
then the judge goes RPR with a whole series of conditions, but RPR is normally released personal recognizance.
Yeah, which would be like an additional promise to appear. Normally, it would be like.
Also, I'm sorry, the neighbor's dog has literally been barking like this all day, and it's constant right now. And because I'm in the lounge, it's louder. So I'm sorry. I hope it isn't coming through too much.
Yeah,
alternative.
Yeah, I don't know. Oh my God, the judge is so loud in my ear. I don't want to log out though.
I mean, it doesn't really matter if Nick needs to come up with $5,000. I'm sure he can do that.
Yeah, he's just going to have to get a hold of somebody. The interesting thing though is representing a co-defendant in the case, because first of all, co-defendants, like we saw in James and Jennifer Crumbly, there could be a lot of conflicts in there. And one of the big issues with them is that they were represented by the same law firm, even though they were different attorneys. And not everyone's case is perfectly aligned. So there could be a conflict. And now we have the attorney who's also a co-defendant. I don't know if that would be allowed in Michigan. Like the judge said, I don't know if that's a waivable conflict. It's very odd. I've never really heard of that. I'd have to do some digging.
I don't see how they can't be in conflict, right? I mean, if either of them had independent defense counsel, one of the arguments defense counsel would want to be able to make is that stuff's not mine; it belongs to the other person.
Also, it's interesting is you saw the arrest was on count 1 and count 2. We knew that. Although it looks like
the charge has changed. It's changed.
The charge has changed.
No longer
Count 1 is now 25 years.
Yep.
Yeah.
So what happened there probably is, they walk in, they find some stuff. They charge on what they think is, well, at the very least, we have this, and count 5 would have been more than a quarter gram, and a quarter gram is nothing, folks. If there's anything there, it's almost certainly more than a quarter gram. So they say, we know for sure we have over a quarter gram, so let's make the initial charge on 5th degree possession. And then when they get the stuff back to the police station and they weigh it, they get a weight, and they say, well, the weight's sufficient to qualify as 2nd degree, which obviously is a substantially more serious charge, from a 5 max to a 25 max.
Whoa.
Yeah, and
so he could face 25 just for the one charge. So it could be more than that. And these two obviously have kids and they're both facing charges, but she's out and he's not. And he's representing her and himself.
then they added the count 3 for child endangerment, which I assumed was coming if this stemmed from an issue with the children being around. Kind of saw that coming. So the child endangerment, however, it's a gross misdemeanor, which means that the children, presumably the children weren't injured in any way. They were just around it while it was going on.
That's partly to facilitate all the CPS stuff they want to do, right? So any CPS hearings, they can now say, well, there's a charge of child endangerment here.
Right, exactly. What I have a question for the chat is Judge Fisher the judge that's been handling Nick's other case, the civil case? And is that the one that apparently Nick doesn't like?
What other case?
Is that the same judge? Yes, everyone's saying yes. Okay,
is that right?
That's going to be interesting.
So the same judge would be handling a civil case and a criminal case?
Yeah, the civil case with Monograph. Yeah.
Huh.
So
is that common?
I've listened to her cover it, or I've listened to her proceedings on that case. And I thought she was reasonable. Now Nick might not like her opinion at the end of the day, but I thought she was a reasonable judge approaching the case reasonably. And so maybe it won't be such a bad thing. Although he has said some things about her, so maybe he could get her removed. get a different judge on the felony case. Kurt, what are your thoughts on Nick representing as a co-defendant representing his wife?
Well, I share the judge's concerns on the potential conflicts of interest. I think it's fine for the purposes of arraignment, which makes sense. So he gets to be her attorney for the next 15 minutes to give her like just the basic advice. Seems okay to me. But yeah, there's a potential conflict of interest because they're both implicated in the same crimes and they might have defenses that are adverse to each other. So that's potentially problematic.
I don't see how they wouldn't.
Also, can I just comment on how absolutely insane it was that some person apparently decided it was a good idea to call into a live court proceeding and basically asked Nick to self-harm?
I know that Uncivil Law swears on his stream, so I'm stopping there. I want to switch to this. So both Kayla and Nick, court pending, possession in the 5th degree, and possesses ammo or any firearm. I don't know what user of controlled means to do with a firearm. Do you know what user of controlled means to do with a firearm? We don't know. If you know, please let me know. And then April, who is his alleged girlfriend, I'm pretty confused on how his wife and his girlfriend both land up getting arrested, unless there's some kind of open relationship going on here, has been arrested for possession as well in the 5th degree. And as far as I understand, he is representing both of those ladies. I don't know what his civil case is. And when I'm looking it up, it's basically coming up with the same thing. Also, does anyone know who Destiny is that people keep referring to? Destiny, and how they are having arguments and I can't find where they fit in either. Anyway, while I dig into that, share this tab instead. So on Friday, when we just jumped into Judge Simpson, there was a whole landlord-tenant that I hadn't watched yet. So I figured we can watch it together, or part of it anyway. Can I move this thing? Oh, sorry. Hang tight, hang tight. What a funny little cat. Okay. What a funny big cat. So yeah, let's watch this together. Put that there. I think what I might need to do is actually just find like one of those deep dives where someone's explaining it, the whole situation from beginning to end, and then report back, because obviously it's a tricky one because a lot of... Wait, guys, this is the best. Just need a Frank cam. What you doing, big boy? Now he's going to come to me. So it seems like a lot of the Reddit is like the same thing. So I'm struggling to find like an overview, and I just want to know beginning to end. And I also want to find points where there's a lot of swearing and just take that out so that I can show you without getting flagged. Anyway, back to Judge Simpson. This is from Friday. This was what happened before we started watching. Which one is the good one? This one? No. Before we started watching the Karen with the pink scarf.
The 14A District Court, Washtenaw County, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge J. Cedric Simpson presiding.
And good morning. Court does call the case of S&C Holdings versus Trevon Steins.
Ready, Your Honor. Tracy Thomas appearing on behalf of the plaintiff.
Yeah, I'm here.
What's your name?
Trayvon Steins.
Okay. What's the claim in the case, Mr. Cohn?
It's a non-payment of rent case, Your Honor. Mr. Stein's total due is $1,754.
Does that include his cost?
It does.
All right. And Mr. Steins, you have a camera?
Yes, sir.
And how do you intend on getting that paid?
I paid $1,000 this week, and then next week. Wait, how much do I owe now?
Well, I don't know. Mr. Thomas, did the $1,000 get credited to?
Your Honor, I got an email yesterday from my client indicating that there had been no payments on this account, so I'll have to look into that.
Yeah, I paid $1,000 this week, and then I can pay the rest probably next week.
Next week when?
I get paid Wednesday, so Wednesday.
So by Thursday, you'll have paid everything.
Yes, sir. I just need a balance. That's about it.
Well, right now they have your balance at $1,754.
Okay.
So what we don't know is if that includes the $1,000 or not.
Okay.
That makes sense to you?
Yes, sir.
All right. So I'm going to put the balance will be paid by May 30th,
okay.
2024. I'll adjourn the matter to May 31st, 2024 at 12 p.m.
Okay.
All right. And hopefully everything will be paid off.
Yes, sir. Thank you.
All right. Thank you. S&C Holdings versus Andre Harris.
Good morning, Your Honor. Tracy Thomas here, appearing on behalf of the plaintiff.
Andre, not checked in. Andre Harris, not here. I'll have to adjourn this out. It doesn't look like you paid for the second service. And you did not.
We've got personal service, but Your Honor, I agree with adjourning it. There has been contact between Mr. Harris and my client, and there's an indication that Mr. Harris is seeking some sort of assistance.
Okay. All right. Well, they would need to be here to tell me that, but that's all right. I'll adjourn it out May 31st, 2024, 12 noon.
Thank you, Your Honor.
Thank you. Is that it for you, sir?
It is.
All right. You have a great weekend and good holiday.
Thank you. You too, Judge.
Court does call the case of Ann Arbor Sportsplex 2 LLC versus Platt Real Estate Company LLC. Are they here?
Good morning, Your Honor. This is Brooke Nosenchuk appearing on behalf of defendant Platt Real Estate Company LLC.
Good morning, Your Honor. Daniel Kramer appearing on behalf of plaintiff Ann Arbor Sportsplex 2 LLC.
And where are we on this, folks? I have a judgment of possession. Is that?
Yes, and it's been consented to by both the plaintiff and defendant.
All right. I had defendants. I just want to make sure because a lot came in. So defendant's motion for summary disposition. I do not need to do anything with that if I have a judgment from me, I'm presuming.
That's correct, Your Honor. We'll be withdrawing that motion.
All right. So we just killed some trees for nothing. No, I'm kidding. All right. All right. Okay. Everything looks in order here. and I will sign the judgment. Thank you folks for working that out. I'll dispose of this matter.
Thank you, Your Honor.
Thank
All right, guys, take care. Have a good holiday.
Thank you, you too.
So true, Sim. I don't know if they had to like.
Coachville versus Sunday Brown.
Good morning, Your Honor, Rachel.
So sometimes I think that maybe because the lawyers are pretty quick to bring forward the case, I don't know if like the person has told them, listen, I'm trying to do my best. I'm going to see where we go from here. Like, I will try to get that money to you as soon as possible. And they start getting a loan or they start trying to make a plan. And the court brings it, the lawyer brings it to court anyway. And then actually they do make the plan that they said they were going to, and it all comes through. I have a feeling that that's what happens, because sometimes it's like alarmingly fast, like weirdly fast. I do not see him being able to stay. Tech guy, is that about the guy who paid the 1,000? Guess it depends if he did pay it or didn't.
Rachel Dornbush, Palace Law on behalf of the plaintiff.
Sunday Brown, you're not here. You have paid for the additional service. Would you? Okay. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Your Honor, Rachel Dornbush, Palace Law on behalf of the plaintiff. Your Honor, the rent to retain of $1,499.41. Costs are $173 for a total due of $1,672.41. And we'd ask for a default possession only judgment with writ issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days.
That's it for me, Judge. And
That's it?
this afternoon, you will have a special guest. It will not be me. So
It
have a
will be
wonderful
you.
weekend.
Well, you have a great holiday, please.
Thanks, Judge. You do the same.
All right, take care. Court calls the case of Kurt Gassel versus Artie Dracos.
Good morning, Your Honor.
And I'm sorry. And also, is it Gadadari?
Yep.
And
Good morning,
Jean
Judge.
Draco. Go ahead.
Good morning, Your Honor. Jay McCurdy on behalf of the plaintiff.
All right. And all right, very good. All right. Are the other two defendants present?
I have no idea.
They are not checked in. So I only have defendant 2. So 1 and 3 are not here. All right. All right. From the plaintiff, where are we on this case?
I received an email yesterday in the evening, late, like towards midnight, that the plaintiff had moved out. We haven't been able to confirm that, yes, or the defendant had moved out. I haven't been able to confirm that this morning.
Tech guy, are you talking about Rekeita? They say, I do not believe he'll be able to stay clean, which will violate his probation. You can tell by his actions he does not regret what he has done and does not think he has a problem. And until he, I mean, like, it's a cliche for a reason, until he acknowledges he has a problem, the problem is not going to get better. Somebody, I can't remember who, maybe I saw it on Reddit, said that they think that he is potentially still under the influence during the arraignment, which is even more like troubling, but not unbelievable if he was literally arrested and then that was the next day, I think, or morning after.
Maybe if I could speak to God, that we can come to a resolution on the case.
Yeah. Good morning, you guys. So I just wanted to inform you, Judge and Jay. So after signing the agreement and prior to moving in, I decided not to move in for personal reasons. Since I've never resided at there was no reason to evict me. I've only agreed to a 12-month contract since I've not lived there. I should have no liability for the holdover period. The Dracos family have solely decided without my knowledge or consent to continue to live there past the contractual agreement. I don't have any possession and I have no right to enter the property. I don't have keys or possession at the property. The agreement.
All right. Hold on.
Yeah, I just kind of made a list of things.
Let me catch up. So had you ever resided at the property?
Never.
Okay. And,
Never.
but there, if I heard you correctly, you signed a leasing agreement, but never moved in.
Correct. I had for personal
Okay.
reasons, I decided not to move in.
Gotcha. Okay. So do you guys know who's residing in the property?
The Dracos family, as far as my knowledge.
Got it. So defendant 1 and defendant 3 may have been residing there, but you did not. Okay.
I did not.
All right. Well, Counsel, what do you want to do on this? Because you've only asked for possession. This defendant two
Your Honor,
says
we
she
checked the
never
box.
had possession. Pardon?
We checked the box for money judgment, and we were actually a little surprised when the court when we filed the case and they didn't accept the Let me see. I have that complaint that I filed. We did check the supplemental complaint for the money judgment.
I don't have payment for any money judgment in the filing fee.
In the filing fee, correct. And we were surprised when the court wouldn't accept it. She told us it was 55. My legal assistant tried to tell her it was more than 55. It should have been about 150. And she only accepted 55 and told us that's what. But if you look at the paperwork.
What do you mean she only accepted?
Your Honor, I sent my legal assistant down there with payment to file the case. And he's well aware that it would have been $150 or so to file this case. But the clerk at the 14A4 insisted it was 55 and wouldn't.
Dear God. Okay. Okay. Well, you know, I just can't do everybody's job. Well, here's part of the.
If you can relate, do this in chat.
Does your client acknowledge that Ms. Dari was not residing there, or?
Correct. Yeah, we acknowledge that.
He knows that.
She is the and no offense to Miss Dari, it seems to be Miss Dari is the only collectible party on this, and she's a like signer or co-signer on the lease, which is why she's named.
Jay, Your Honor. So as far as my knowledge, and again, I'm as green as possible, and I'm representing myself. The agreement did not have did not reference a notification. So when I decided not to move in, the Draco's family said they'll take full responsibility for that 12-month period that we signed. So,
well, okay, let me back up a second. The lease, the original lease, or the lease, the only lease, I guess, that has expired.
Yes, Your Honor.
Okay, so had there been let me look at your complaint. How much was monthly rent?
$3,800
a month.
Correct.
So the only, and correct me if I'm wrong, the only rent claimed, if I'm looking at your complaint here, is rent after the expiration of the lease.
Correct, Your Honor.
Which Ms. Dari, although not even residing there, her liability would have ended at the end of the lease.
Wouldn't she be considered jointly and severally liable for the holdover period?
No.
That's going to be a question because outside of never moving in, let's forget about that for a moment. If she signs a contract, she fulfills that contract in essence because everything is paid. She's not there. She moves. I don't have a copy of the contract, but I don't know that it's joint and several once the holdover period because she's vacated. There are other people that are in the premises. Now, there may be a theory upon which she might. Pardon?
She never vacated, Your Honor. She never moved in. I believe that they used. My understanding was her like credit was used to justify their like ability to move in.
And that's incorrect. I was actually planning on moving because due to personal reasons, I'm going through. Again, I'm not putting my information out there. My personal.
No, you don't have to.
I don't have to.
It really doesn't.
I'm going through a personal.
It really doesn't. It may not matter for the purposes of the case. It might, as to your reasons, but at this juncture, I don't think it does. So we got to correct a couple of things in here. First of all, I don't understand the 99 on this. What do you? I have under service, Washington County Sheriff's Department, it says plus 99.
That might have been service for all three individuals.
Yeah.
That must have been 33 at each. Okay.
It's 28 for two of them and 43 for another.
Got it. Okay, fine. But what has to be corrected
He's so frustrated.
is the money judgment.
I can drop off a check for the difference, Your Honor.
No, I know, and I guess for educational purposes, they don't know who they spoke to.
I can find out. Ethan probably wrote it down. He's very,
Okay. All right, why don't you do this? I'll indicate defendant to pay for the money judgment filing fee. Whatever that is. So get a check there and we'll deal with that. And then I'll adjourn this out to the 31st, 2024 at 12 noon. Okay, now ma'am, are you intending on being represented or?
No, I'm representing myself.
All right, very good. All right, plaintiff is also to, I don't have a copy of the lease that was there. I realize it's a holdover situation, but with Ms. Dari's particular position in this, I'm going to need a copy of the lease that was applicable to the premises. So I'll indicate plaintiff to file a copy of the lease.
Your Honor, that was also dropped off, but I will drop that off as well.
Was it?
Yes, sir. Yes, Your Honor. The full packet.
Yeah, I believe you. I just
14A4 is out there.
You get me a name, please, if they've got it, because this is. I believe you did what you say you did, and I don't have anything. So, all right. And if you, I'll tell you what, counsel, why don't you send a copy of the lease directly to us?
Okay.
All right.
Thank
you. That way we'll have it.
Do they know if it's filed immediately when they filed, or did they stay and watch the clerk file it?
I don't care.
I was gonna get you a name of that.
Oh, you were gonna give me a name?
Yeah.
Okay, no, we'll figure it out. We'll get that corrected. He's gonna pay the filing fee and then he's gonna send, if you can send that directly to Ann at my office.
14A1.
He'll put an email, she'll put an email in the chat for you.
Thank you.
All right. Okay. Ms. Dari, any questions you have, ma'am?
Just the Zoom ID, is it the same one for the 5:31 noon?
On the 31st?
Yes.
Yes.
Okay, thank you so much.
All righty, thank you.
I'm sorry if you
Have a
want
great
to call
day,
my office at any point. Feel free.
I'm sorry?
All right.
If you ever want to call my office, that's fine. We can discuss this further.
Okay. Thank you so much. Have a great day.
Thank you.
Bye, guys.
Okay, so I have the next hearing written down. And my advice to Miss Dari is that ChatGPT might be her friend, because I just went and tried to like understand for myself. Okay, wait, before I get to that, other attorneys are thinking he's going to attempt to go pro se, even though he is a lawyer. That's referring to Rekeita, and that is what I understood from the arraignment as well. And what comes to mind is the saying, a man who represents himself has a fool for a client, or something like that. I wouldn't do it. So here's a ChatGPT lawyer, so pinch of salt. Here's the understanding of this. So my first question was, what is a holdover when referring to a housing lease? And it says, a holdover in the context of a housing lease refers to a situation where a tenant remains in the rental property after the lease term has expired without the landlord's explicit permission to extend the lease. This can lead to different legal consequences depending on the jurisdiction and terms of the lease. So then I said, if the person signed for 12 months but didn't move in, then what would the holdover be? Then they say, in this scenario where a tenant signed a 12-month lease but never moved into the property, the concept of a holdover doesn't directly apply, as a holdover typically involves a tenant remaining in the property beyond the lease term. However, there are still important aspects to consider. 1, lease obligation. Even if the tenant never moved in, they're still legally bound by the terms of the lease unless the lease contains a clause that allows for termination if the tenant does not occupy the premises. Rent payment, the tenant is required to pay rent for the entire terms unless otherwise agreed. Landlord remedies, the landlord may seek to enforce the lease, so the tenant has to pay the full time. So what I think happened is that she signed the full lease. The other two told her that they would like take it over, or they would essentially sublease it. And that's why she's the only billable defendant, Because why, if there's 3 people on the lease, why would only one be billable and why would only one be held to that if she didn't move in? That's the only thing that I can think of. But hopefully on the 31st, which is this Friday, she'll be back and they'll have a lot more info. They obviously also need to get hold of the other tenants because they're the ones still in the property. My guess is that the reason she didn't move in is potentially some kind of breakup, relationship ending, because she said personal reasons, doesn't want to put her business out there. Shame. Bit of a tricky one. But she did well. She had her points written down. She clearly had done her research. She knew what she needed to say, what points she should touch on. So I think she'll be okay. All right. I think I will watch for another 20 minutes or so, and then I need to have dinner because it's 7:30.
Have a good day, Your Honor.
You do the same, sir. Barnes and Barnes versus Justin Liskey.
Oh, that was Friedman for the plaintiff, Your Honor.
Justin Liskey.
All right. Mr. Let me see, is it on both of them? Just so that you know, I don't have on your cases, for whatever reason, Mr. Friedman, proofs of service, but I don't know that it's going to matter on one of them, but we don't have them. Well, we might, and they're just not here. I don't know. All right. Anyway, what's the claim in this case, Mr. Friedman?
Total 2672.
2672?
Yes.
All right. And sir, what do you have to say about that, Mr. Liskey?
I'll be making a $1,000 payment tomorrow.
Okay, you're going to pay $1,000 the 25th. Okay, and then you got about 1672 balance.
Is this attorney one that we've seen before, or is this the same case we've seen before? Because he seemed to answer that to pay really quickly. Renee says more pizza. Well, there actually is still pizza in the fridge. But no, we're going to have, there's a few options. We're doing leftovers because there's like a lot that we need to eat today or tomorrow. So there's still roast, there's cottage pie, there's pizza, there's something else that I can't remember, probably pasta or other pizza.
Balance then, how are you going to get that paid?
I should have another 1,000 the week after, and then I lost my job.
1,000. Hang on a second.
Yep.
You're going to pay 1,000 on the 25th, and then what? 1,000 on the 1st?
Yeah.
Okay, but your rent's going to click in. So how
Right.
much is monthly? How much is monthly rent?
$9.95.
Okay. Let's do it this way. I'll adjourn the matter out 1 week to the 31st. You pay that 1,000, but understand something, sir. If it's at noon.
No, that's gonna be at 3.
At 3, this is the 31st at 3 p.m.
Okay.
If the 1,000 is not paid, or at least the 1,000 is not paid, I'll just be granting them a judgment because you're going to get that paid. Otherwise, we'll see how we can get this structured so that you can get this paid and get yourself back on track.
Okay.
All right. Okay. Thank you. 31st at 3.
Cottage pie, how do I explain it? Do you know what shepherd's pie is? Cottage pie is mince, like bolognese, but a little bit, kind of a bit more savory than bolognese. And then it's got mashed potatoes on top. I think there's like a little bit of carrot in the bolognese, but shepherd's pie has the cheese on top, and I think it's lamb mince. This is beef mince, beef/pork. So basically, like, the options are like bolognese inspired, or bolognese inspired. I did say that I love bolognese, so
3 o'clock. Glen Oaks Cooperative versus Kelly Andrews.
Your Honor, we're going to be sending out a conditional order of dismissal on that.
I'm sorry? I do.
You mean?
Yes, sir. I have it in front of me. I'm sorry.
Yeah, I'm going to
Wait.
do COD on that.
is that our mold guy?
This case is conditionally dismissed, and I've signed off on that.
Thank you.
Are they here? Yes. They did not check in. Oh, pardon?
Yes. Here.
Oh, there you are. Okay. Hold on a second. What's your name?
Dane Jones.
Okay. Is Kelly Andrews here? They're not, so I've taken care of that. All right. Thank you. Court calls the case Glen Oaks Cooperative versus Dana Jones.
Your Honor, he's basically all we've got is cost, so we're going to dismiss.
Okay. Sir, is your name Dana or Damon?
It actually is Dane Jones, Dane. They got me as Dana. Yeah.
It's not him.
I got 3 names for you. It is
That's
too early
ridiculous.
on a Friday for me to be dealing with this. All
That's
right,
quite
but
coincidence, Your Honor, 'cause I'm the
you're
third.
at Glen Oaks.
Yeah.
Okay, and that's a 1429, correct?
1429, correct. Yes.
Okay, that case is dismissed, whoever you are. Okay.
Okay. All right.
All right, thank
Y'all have
you.
a blessed day. Thank you.
You do the same.
All right.
Is that it for Mr. Friedman?
Oh my gosh, I just want to bottle his laugh up and listen to it on a bad day. That is such a wholesome laugh.
Okay. Now let's take care. Have a good holiday. I know you will.
Thank you, Your Honor. I'm on my way to get on to 23 about 5 minutes from now.
Okay. Good luck on that.
What does that mean?
All right.
Okay.
Sharon Bell versus Melissa Mason. Miss Bell? Oh, you need to unmute.
Unbelievable. Can you hear me?
All right.
Yeah.
Yes, now I can hear you.
Oh my God. Good.
It's okay. What's your name?
My name is Sharon Bell. I'm the plaintiff.
Okay. Yes. And is Mason here? They are not. Okay, so I have one problem with your case, ma'am, and that
Okay.
is I don't have a proof of service.
A proof of service meaning
is that?
the summons didn't go through for her?
Yeah, it doesn't, I don't know, because I don't have anything to indicate that she was served with the paperwork.
This is the problem. She abandoned the house and her children and is,
Okay, no, well, I don't know that, but I now know that. But if they're not there, then there at least has to be some type of service, like posting on the premises, whatever. But
I did give her a notice to quit and I did have a witness.
no, the notice to quit is not my problem.
Okay.
My problem is that the complaint that you filed, there has to be a proof of service filed. So there would have been a mailing that went out, but there has to be, somebody has to serve that complaint.
Okay, the situation is the person is not in the home.
I know.
The
told me that.
grandparents are in the home. They've communicated with her, but there's no proof, like you said. So what do we do? She just vaporizes and
I don't have proof of service or attempted service.
meaning that you don't have proof that she's been served.
Correct.
Right. And
So I can't proceed.
can I do this? Do I talk to the sheriff to tell him where I? think
Yes, you can
maybe?
talk to the sheriff department about service on her.
Okay,
I'll adjourn it out a week for you to try to get that accomplished.
okay, thank you.
All right,
Yep.
May 31st, 2024 at 12 noon. Okay?
Wow.
Sounds good.
All right, thank you.
All right.
What was her name?
Court calls the case of Barbara.
Sharon Bell. My reference is going to be vaporized. 31st at noon is going to be a good hearing.
Barbara 1 versus Derek Graham.
Good morning, Your Honor. Cheryl Welkoff on behalf of the plaintiffs.
Derek Graham has not checked in. You paid for additional service. Would you like to proceed?
I would.
Do you
Your Honor.
solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Your Honor,
Go ahead.
plaintiffs for a default judgment. This is an action for possession due to lease expiration. The notice was sent pursuant to MCL 554.1341. And we are asking for a judgment of possession only with the writ date of June 3rd, 2024.
Judgment to the plaintiff by default.
For the people listening, not watching, I know I saw someone said they're only listening. So the first comment that I was laughing at is Renee says, I made really horrible shepherd's pie once due to lack of proper ingredients like 30 years ago, the only meal my husband still talks about. So I'd say our version of that would be this. How do I put this in a YouTube friendly way? Do you know which one I'm talking about?
Macaroni.
Yes, he knows exactly what I'm talking about. I made macaroni and it landed up coming out like
It didn't have a very good consistency.
the consistency was terrible. And I'm a decent cook. I'm pretty good. And so
Sauce consistency.
the sauce consistency was
Suspect.
think of like white, creamy, kind of goopy, translucent. And the word is basically like if you were to say, come over here, but you mean it in a different way. So we called it Cameroni. YouTube can't see how I spelt it. It's fine.
Okay.
And then the other comment was Sim said 23 might refer to Highway 23 in Michigan that is having major construction done on it. Certain interchanges are closed for 5 months. Wowza. Well, if it makes you feel better, there is a road in Cape Town that I can't even tell you what year of construction it's going on. It's pretty much, I'm sure that they started the construction when roads were invented, and it is still going. So on a Friday afternoon of a long weekend, I can only imagine what he was looking forward to on a road with construction and at the end of a day. Because I think this was the second last one. So it was like the 3 o'clock or the something like that. Renee says, I'm an amazing cook. Every town has that road. Yeah, but this is like record breaking. This is like, it's one of our highest tourism areas. So everybody, when you speak to people about Cape Town, they ask about the penguins. If you want to go see the penguins, you have to drive on this road. And it's been like that for longer than I've been alive. I'm pretty sure actually before roads were even invented, when it was horses and carriages going down there on the dirt road, they started construction then. And it's still like that. Okay, so I want to see. Okay, let's do another 10 minutes or until the closest end of the next story, if it's just after, and then I need to head off.
No redemption amount, writ issue 10 days.
Thank you, Your
Thank
Honor. I have
you.
one case at noon and I'm sending in a dismissal right now. So
Oh, okay.
do you want me to
Well-
log back in at noon for that?
No, well, we'll take care of it.
All right, thank you so much. Have a wonderful weekend.
You do the same.
Thank you.
Your Honor, the next case requires a Spanish interpreter. May I swear her in?
Yes, you may.
Good morning, Madam Interpreter. You're in front of the Honorable J. Cedric Simpson out of 14A District.
Esto es para terminar
Within. Is to try to obtain.
y también pues
Oh dear. Well, that was timing. For the interpreters, what I'm trying to do is when I edit the court streams, I cut it so that there's only one answer, so that there's not the back and forth. So if I watch it back and it's super interesting, then I'll do that. If not, then we don't really need to cut it out.
Additional assistance is our possible resource.
Judge, do you mind joining us, please?
Draw near the Honorable Judge J. Cedric Simpson presiding.
And good morning. Court does call the case of Arbor Meadows versus Hector Molina.
Oh, I thought that was Kylie Jenner for a minute.
Mark Ruby on behalf of plaintiff.
They are not checked in. Hector Molina, no response. You paid for the second service. If you'd raise your right hand to be sworn, you may proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, plaintiff moves for a default judgment in this matter for possession only. We've got I'm just making sure it's possession release. We've got rent owed in the amount of $1,918.33. Court cost of $175. Total is $2,093.33. Your Honor, we are
At 293.
yes,
Okay, go
293
ahead.
and 33 cents with a requested writ date, Your Honor, of June 3rd.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested, writ issue in 10 days.
Thank you, Your Honor.
Arbor Meadows versus Pedro Quijada.
For the record, Your Honor, Laura Kirby on behalf of plaintiff.
Pedro Quijada. No response, you may proceed.
Your Honor, plaintiff is requesting a default judgment in this matter,
Sorry.
possession only, rent owed in the amount of, what is it?
Go ahead. No, it's something here, not you.
Oh.
Go ahead, Doug.
Rent owed is $1,049.94. Court cost is $175. Total is $1,224.94. And same writ date, Your Honor, June 3rd.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ issue in 10 days. Then I've got Arbor Meadows versus Carmona, Arbor Meadows versus Hernandez Salazar, Arbor Meadows versus Thomas Miller. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor.
Thank you. Is that it for you or you got more?
I've got two more.
These other two, gotcha. Augusta Woods versus Rhonda Tucker and Steven Tucker.
Laura Kirby, Your Honor, on behalf of plaintiff.
Rhonda Tucker's here. Ms. Tucker, can you unmute? State your name.
Yes, Rhonda Tucker.
All right.
Can you hear me?
And what's plaintiff's claim in this case, including cost?
Your Honor, this is actually termination of tenancy.
Oh, it's a termination. I'm sorry.
It's okay.
All right. Ms. Tucker, what is your position on the termination of tenancy?
I disagree with it.
Okay. Are you going to get representation or how are you planning on proceeding on this?
I mean, my understanding is if we can come to an agreement on dismissal today, then that would be the end of it. Otherwise, then we would set another date and then I would be obtaining representation.
Well, when you say dismissal, you're talking some conditional dismissal with conditions?
I mean, I'm not sure. I was just listening to what was being said. Maybe I misunderstood how it was being,
Oh, I'm making a note of her. Don't worry. We'll watch her
Okay,
through.
what would you like to do? I guess is my question.
You mean in regards to, okay. What I would like to do is stay in my home is what I would like to do. That's what my husband and I would like to do. So I guess if we have to go to trial to do that and I'll obtain a representation in order to try and secure that, then that's what we'll do.
All right, then what we'll do is I'll adjourn this out 1 week to allow you an opportunity to speak with an attorney.
Okay.
Okay?
All right. So next
So
Friday.
I'll adjourn it to May 31st, 2024 at 3 p.m. You'll need to file an answer.
Okay.
Prior to that date to the claims.
Okay.
So you'll need to file that by the 30th.
All right.
Okay. And what I will do is I will indicate escrow at this point is reserved.
And what does that mean?
That means that plaintiff, I would imagine, has not been accepting rent.
Yes, they have.
Well, you're paid through what date?
May 31st.
Counsel, is that correct?
I have no knowledge of that, Your Honor. Ms. Tucker, when did you make that payment?
The 1st of May.
I believe, Your Honor, it was during the period of the 30-day notice that was sent out, but we don't accept payments after the 30-day expires.
Well, no, I know, but we're gonna have a problem. Because counsel, if they accepted rent after April 15th, which is the expiration of the notice in this case, then we got a park course problem.
Understood, Your Honor. May I ask Ms. Tucker if this was an auto pay or did you go in there personally and?
No, I went in there. I went in there personally.
Okay.
Like I do. I don't have anything set up on auto pay. I never do.
Your Honor, what I can do is if my client isn't here, but I can confirm today, and if they did accept payment for the month of May, I can ask them to return it to her and she can escrow it with the court.
Well, I don't think that will work. Certainly that could be your position, but if they accepted rent after, well, and there's gonna be even more of a problem because if they accepted rent in April, we're gonna have a problem. And if they accepted it
Which they
certainly in May, we're gonna have a problem. But what I'll do, counsel, is, ma'am, you need to, how did you pay your rent in April and May?
I pay it online through their,
Okay.
yeah.
So you have proof of the payment of rent?
Yes.
Okay, so you need to provide that to the court by the 30th also, okay?
Okay.
Because that may take care of certain issues or may take care of the case, quite frankly, but we'll see. All right, I'll adjourn it out to the 31st. I'll expect to see an answer as well as those things, and then we'll go from there. Okay?
Yeah. I apologize. Is this in person?
Via Zoom. We can do it. Zoom.
Okay.
All right. Thank you.
Thank you, Your Honor.
Oh, I
Court
can't wait.
does
for
call the
31st.
case of, which one do you have up there? Beal Properties versus Jennifer Hazel Baker Rollison.
Laura Kubiak on behalf of plaintiff.
And there's also another defendant, Casey Field. Just
Hey Josh, I mentioned something the other day. I can't remember. Might have been to do with the Karen thing. Just before. I can't remember. Anyway, Renee, I hope you have a good day. I'm sure you've left already. I was on the tab of the court, so I didn't see this. But if you do rewatch the end, thank you so much for hanging out, and I'm glad you were here. I'm going to finish the stream and then head off because I'm watching on 1.25 speed, so less than 7 minutes left, 6, 5, something around there.
just a lot shorter. Okay. Mr. Field? Can you hear me, sir?
Casey Field here. Yes, can you hear me?
You're breaking up pretty bad. I can see you moving, but hang on. All right, Mr. Field, we're going to shut down your video to try to increase some bandwidth. Now, can you hear me and try to talk to me, sir?
I think it's his headphones.
He's taught, but
so I think it's his headphones because when he was talking and it was going, it was like when the cable was moving.
can you communicate to him? His connection is horrible.
Oh, here you are.
What?
Mr. Field?
You just said, I'm not sure why I'm having issues. I have full network strength.
Okay. Tell him to sign out and sign back in. All right, counsel, I'm going to pass it briefly. We're going to have him, you probably heard me. We're going to have him sign out and sign back in to see where we are. Okay. All right. Once he pops up, I'll call it. But court calls the case of Amara versus Scoops Cold or Cold Scoops.
Good morning, Your Honor. Lillian Engen for plaintiff.
Ma'am, your name?
Sarah Simmons for Big B Coffee, which is Cold Scoops LLC.
Yeah, could you repeat your name? We didn't catch it.
Sarah Simmons.
You got it? Sarah. Okay. All right, ma'am. Before we go any further, you're the owner
Correct, of Cold Scoops.
of Cold Scoops. Okay. Is Cold Scoops it's an LLC?
Yes, it is.
Okay. So in order to proceed further in court, Cold Scoops is going to need to have an attorney represent them. The corporation does.
Okay.
Okay, so how long will it take you to get an attorney on this?
I don't know. It's the first time I'm hearing that one was going to be needed for the LLC.
Say it again. You're a little bit close to your mic, so I'm having some problem hearing you. Okay, go ahead.
Sorry.
What were you saying?
This is my first time hearing that an attorney was going to be required for the LLC.
Yeah, you're going to have that for the corporation because that's who's here. Yeah. Okay. So this is a non-payment of rent. How much is claimed?
Including court costs, Your Honor, I have a total of $22,833.40.
Okay, you're going to have to repeat that for me. You guys have opposite problems with your mics. So say that again for me, the amount.
I have $22,833.40.
Got it. Okay. What I will do, ma'am, is I'm going to adjourn this out 1 week, allow you an opportunity to get an attorney.
Okay.
To represent Cold Scoops. So I'll adjourn it to May 31st, 2024 at 2 p.m.
Okay.
Okay?
All right,
And then
thank you.
we'll see where we go from there.
All right. Thank you.
Thank you. And did he sign back in?
He has not signed.
New Park Ridge Apartments versus Barry Tomlin.
Jillian Engen for plaintiff.
Not having checked in.
New Park Ridge, Tomlin. No, he is not here. If you'd like to proceed, you may be sworn. You raise your right hand.
It's my right hand, Your Honor.
Okay, no, it is.
We still have
Do you
the same
solemnly
problem.
swear? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but?
This might be a dumb question, but why does it have to be your right hand, not your left hand? Also, I just realized that my little banner thing is cutting me off. Why does it have to be your right hand, not your left hand? What difference does it make? Josh says, I rewatched the stream from a couple of days ago, and that Karen definitely doesn't understand the court. And she's still calling herself an attorney. Oh, if she's acting as an attorney, surely she should be disbarred or something. It's bad.
That's true stuff you got.
I do.
Go ahead, please.
Thank you. This is a case for non-payment of rent. I have rent to retain possession of $181.95, court costs of $176 for a total of $357.95. Plaintiff is requesting a default judgment for possession only with the writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. Writ to issue in 10 days. No writ without a hearing.
Sim, I hear you because the left is on the Bible, but surely the right could be on the Bible
Also
and the
case
left.
of Z Partners versus J.K. Whitley Investments.
Jillian Engen for plaintiff.
John Whitley with J.K. Whitley Investments.
Okay. And
Wait.
Mr. Whitley, let me.
Wait. Does anybody else watch TikTok drama? J.K. Whitley, I'm telling you, I'm going to go back and watch Marky. This guy, I'm pretty sure, is the dad that left the family to become a break dancer. I know. It's Vaughn even looked at me like, what? I'm going to make a note. I'm pretty sure it's the same guy. But he is heavy into crypto, potentially some scammy stuff. Left is close to the heart. Same reason for wedding rings.
Let me ask you this. Is this an LLC or corporation?
It is an LLC.
It's an LLC?
Yes.
Okay. So you're going to need to have an attorney represent the LLC. How long will it take you to get an attorney, you think?
I would imagine 2 weeks at the very most.
All right. How much is owing in rent?
I have a current balance, including court costs, of $20,818.62.
Gotcha. Okay. So, sir, what I'm going to do is I'm going to adjourn it a week for you to get an attorney. All right. And the reason I'm doing it is because of the amount that's owed. And I trying to at least get something accomplished before we click into another month. All right. So I'll adjourn this to May 31st, 2024 at 2 p.m. All right, and then
Okay.
once you have it, then we'll see where we can proceed from there. Okay?
Okay. All right. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. That's all I have. I
Okay.
hope you have a good rest of your day.
Is that it? Glencoe Hills versus Jermaine Ballard Tab. That matter's dismissed. Oh, Mr. Fields is on back. Oh, there he is. Okay. Beal Properties versus Jennifer Hazelbaker Rollinson and Casey Fields. Mr. Fields, you there?
Yes, Casey Field here.
Oh, much better. Much better.
Sorry about the trouble, Your Honor.
No, not a problem. Okay, counsel, what's the claim in this case?
Your Honor, we've got rent owed in the amount of $1,699, court costs of $214, total is $1,913.
All right. And sir, how are you intending on getting that resolved?
Well, here on Thursday next week is our next paycheck. Me and Jennifer both work at Multicultural Academy. It's a Title I charter school down on Platte Road. She's actually there at work today. I took off to be here. We should be able to get that amount completely taken care of. I know that new rent will also be coming due on the 1st. I'm not sure if we can support both this back amount and that on the 1st, but 100%.
Well, hold on. So when this back amount, because that's all that I have before me at this point,
okay,
the 1913, when can you get that paid?
We get paid on Thursday and we'll be able to pay that then.
So you can get it paid by the 30th?
Certainly.
All right. So what I'm
I
going to
can
indicate
schedule it on the 30th when we get it in our accounts.
Say again?
I can have it scheduled on the 30th when we get that money into our accounts. So,
all right. So here's what I'm going to do. I'm going to indicate you're going to pay the balance by May 30th, 2024. I'll adjourn this proceeding out to May 31st, 2024 at 3 p.m. So get that paid, and then this likely goes away, and then at some point you'll have to work on June or figure out June.
yep, that'll be taken care of as soon as possible.
All right.
I just found out about this last night. I've been dealing with losing my mother and actually canceled my plans to attend her ceremony on the 29th to make sure that this is all handled, because this is important. I don't want to leave anybody short just to take care of other stuff.
Gotcha. Okay. All right. Well, our condolences on your loss.
Thank you.
Okay.
And just to make sure, because I had a number written here of 1833. You said it was 1,913, ma'am?
I apologize. Let me get the file.
Yeah, that was.
Yeah, it's 1,913. It's including court costs.
Okay.
$14.
All right. I will have that submitted to the Beal website as soon as we get paid.
Thank you so much.
All right. Fantastic. Thank you.
Thank you, Your Honor.
All right. That's it for you, counsel. Thank you.
Yep, me. Have a good holiday weekend.
You do the same.
Okay. Jewish writing on the subject often stresses what book the left hand is resting on rather than the significance of the right hand being raised. Interesting. So I found the video of the breakdancer. And it seems his name is Ben Hart. I'm going to put the link in the description as well. If you don't watch Marky, he is one of the best like TikTok drama channels because he just makes it relatable. Let me just quickly do this. Breakdancing dad leaves family. I've put it in the description as well. And it doesn't look like it's the same guy, but he does look very similar. And I'm going to go back and rewatch it now because I'm pretty sure it's the same dude. And the crypto signs and all of that. Excuse me. Anyway, thank you for hanging out. Very impromptu. My Zurich vlog just went up 6 minutes ago. So if I knew how to portal, I would portal you there, but I don't. So you're just going to have to click, I guess. Sorry. What I can do is I can put it in, wait, scheduled for 28th. Oh, oopsie. Tomorrow night. I can always say, let's do this today at 8:15. Schedule. The only thing is, I can't share the link. Oh, anyway, if you click on my channel, go to videos, it'll be up there in 6 minutes roughly. Josh says, see you tomorrow to watch Karen read on RA. I sincerely hope so. I have a very hard deadline for Wednesday, but I need to know about the text messages that everyone is talking about. And I've managed to get myself to the end of today without going and looking at those text messages, but I know that they're spicy. And I really, really, really want to know the deal. Also, if anyone knows about the rest of the story with Rekeita, what the civil thing is about, please let me know because I would like to read up more on that. And also, just a reminder, if you go and look at the description, there's the link for that whole thing. He might actually say in there. I didn't get through the entire thing because I was like, I need to talk about this on the stream. I've been watching KR and EDB. How's the commentary on RA? I think it's been pretty balanced. I think most of us, myself included, are leaning towards not proven or reasonable doubt. But there have been a few things like Kerry, the witness who was there, who was with her and Jen when they went to the house. I found her very believable. And she made me think that there is a possibility that Karen did it. Also, the commentary there is very much staying away from the drama outside of the court, like with Turtle Boy and the other person who I'm not even going to mention because I'm sure there's like bots looking for answers about that. But I will say that I was very much not a fan showing Petito when that happened, and I don't like what's going on there, but maybe once it's over I'll talk about it, because I remember with Gabby Petito we like rabbit holed and found out that this person is a convicted fraudster and somehow pops up over and over. And yeah. Anyway, it's literally 5 minutes till my vlog goes up. I just wish I could set it for 10 past. Wait, they will let me type. No. Now you're just going to stare at me while I sort this out. 8:12. There we go. So you can basically, in the time it takes to go from the stream to there, it's perfectly aligned. You don't have to go look for something else to watch. I mean, no pressure, but just in case. I will see you guys tomorrow, either in chat or yeah, I hope I can be in chat tomorrow. So let's just put it out there in the universe. I will see you tomorrow. Bye.